Mr. Speaker. Mr. Speaker, the matter upon which I stand here to speak on is one that is of utmost importance to this National Assembly, to our Constitution, and quite frankly, to our country, as it is a republic today, and of course, more directly to all members of this National Assembly. I cannot overstate the significance, the importance of this very important topic that we're talking about. And I want to indicate that indeed that it goes back to largely research as to what is a concept well known in the House of Commons in England and also the House of Lords in England, which were the places of origins of what is called standing orders, conventions, privileges, immunities, and powers of parliament, and all those concepts. And so it is important that we, to give the majesty of our Republican National Assembly here, to delimit its powers, privileges, and authority on any question that the majority in this Parliament seek to promote. It is the House of Assembly, the representatives here on voted that we in this Parliament determine, deliberate on the issue of this motion. And when the Honourable Attorney General got to speak and to make his inadmissibility objection at that point, I thought it was wholly untimely, largely because the vote was that we in this Parliament will proceed with this motion. And to a certain extent, if not explicitly, it was made clear that it is admissible for us to proceed ahead with it. And so, as regards the question that it is inadmissible and it can't now be determined, I think the Honourable Attorney General missed the boat when he was so untimely, and I wish to make that as a preambular argument. There is another argument that the learned Attorney General indicated that again seems out of place, and that is that our standing orders are not law. Our standing orders are something less than law. I wish, however, to remind him that the Constitution Act that brought the Constitution into being, of our Constitution, indicated in section 6 thereof that standing orders are here to stay, and it shall be the law governing our Parliament. This is our Constitution, and our Constitution, of course, without an Act of Parliament, and that Act is cited as the Constitution of the Cooperative Republic of Guyana Act, 1980. The Constitution is merely the schedule to this Act. Clear. This is what Section 6 of that Act says. Section 9, sorry. Section 8 deals with Parliament. And Section 9 now talks how we govern this Parliament here, which is this National Assembly. The rules and orders of the existing Assembly, and that was the Assembly just prior to the passing of this Act, as in force immediately before the appointed day, shall, until it is otherwise provided for under Article 165 and Article 173 of the Constitution, as the case may be the rules of procedure of the National Assembly, and of course at that time we had the Supreme Congress of the People and all that, which has now been abolished, and shall be construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with the Constitution. Our standing orders then have gotten what is called this sanctification of a parliament, and a parliament that indeed had not only this National Assembly, but a president assenting to. Now, if we do have standing orders by this Constitution Act indicating that the rules governing Parliament are called standing orders, I cannot see how it is that our Attorney General is going to say that we do not have what is called law governing the procedures of this Parliament. It has the force of law. There is nowhere that says that it does not. There is nowhere that says it is not. And you must understand that. Mr. Speaker, if that act could bring into the fore the entire Constitution, why can't that act by Section 9 says that indeed standing orders is what be governed by them? Now, I also want to bring to the attention of this Honorable House that my learned friend, apart from being very misconceived in his argumentation about the sub judice rule, that he wants to make this motion inadmissible, is saying that there is something in the standing orders that he now wants to use to gag all of us. So he uses this rule, called the sub judice rule, to state that we in this Parliament cannot speak because there is something in the court. Brought by him. Yet he quotes the article in the Constitution, the right to speak, and he's urging this Parliament to state that because Mr. Rohee get the right to speak under Article 146, he should speak. But where the sub judice rule is not explicitly stated as a qualification, he wants all of us not to speak. He wants to gag all of us by virtue of a rule in a standing order that he is saying is not really law. This thing is riddled with what is called self-contradiction by the Attorney General. I want to indicate to you, sir, that our standing orders are rules that substantively govern the exercise, the discipline, the organization, the management of this National Assembly. And we must respect those rules. And if we're going to use the Constitution now conveniently to say, but there are exceptions to freedom of expression which doesn't qualify, why does he not say that there is nothing in the qualifications that say sub judice prevents people from speaking? He doesn't. Mr. Speaker, I have gone through your scheme in relation to this sub judice rule. And our scheme, which is the authority, we call it the Bible, has on several of its pages that it is at the discretion of the chair, that's the speaker here. I will quote the passage just now. And there is a good reason why it is at the discretion of the chair. To begin with, matters of national importance can be gagged by virtue of a simple application of the rule and not understanding its origins and the purpose behind it. We argued this thing very extensively when we wanted to bring a motion for the investigation of CLICO. They had a majority that time, and indeed it was a rule like that chair that, okay, they will not deal with the matter because there was a CLICO motion, there was a CLICO litigation in court. But assuming now that we want to bring to the parliamentary's attention matters of national importance, and quickly the Attorney General run to the court and file an action that obviously would have absolutely no merit. It's vexatious, like the very first one, committee of selection, and then comes to this parliament when we are about to deal with the motion.
One more caution, and even though I am a named respondent in that matter,
yes,
I would ask that we refrain from classifying it as vexatious or otherwise.
Well, as a matter of fact, sir,
myself and the leader of the opposition, I think that one's entitled to describe it as such because we're named as a respondent. But
that's it.
That aside, let us avoid the adjectives.
Yeah, but whatever the adjectives are used, it could very well be one that is without any substance, and then they come into Parliament and use it to gag all of us.
Yeah.
What happens then? And that is exactly what I'm saying, that flawed and misconceived applications can be brought, which can then be regarded as shams to the extent of blocking in this Parliament, in this National Assembly, motions from being debated, bills from being brought, whatever it is. And so the actual House then stifled from carrying out its work. And that is what I am saying. It could never be the purpose of that sub judice rule. To gag the entire National Assembly from proceeding on its debate. So when my learned Honorable Attorney General indicate to this Honorable Assembly that the sub judice rule is priority number one, all of us are gagged if there's a ruling that indeed that be so. But his right to freedom of expression for Mr. Rohee under Article 147 overrides all of that. It is contradictory to the core. And to that extent, Mr. Speaker, I want not to allow us, by virtue of that kind of circuitous argument, to say that we ought not to hold that this motion is admissible. It is very much admissible. There is also, Mr. Speaker, a larger principle that I wish to draw the attention of the National Assembly. And that is, because we're a republic now, we must give a status that is equivalent to the powers that be in relation to the House of Commons on matters of this nature. And our standing orders, which I have argued already, are very much law that governs this Parliament, means that we must adhere to those standing orders. And the standing orders indicate that where we are silent about certain usages and practices, we must go back to what is in the House of Commons. And what is it that is in the House of Commons now that we have a silence on this convention of ministerial responsibility? I went through very thoroughly at the last debate, quoting Diana Woodhouse and ministers and ministerial responsibility, that indeed it is a convention that when under the stewardship of a certain minister things have gone wrong, minister must resign. But more than that, when you have a no confidence motion being brought against him, it is a double whammy. Not only has the atrocities that occurred under his watch the basis for it, but we additionally brought a no confidence motion against him. And as you even mentioned in your ruling, in any other Commonwealth country, there would have been a resignation. Now what that means, by the minister not resigning or his president not, dismissing him. That a command of this National Assembly is being violated. It is a command by virtue of it being a resolution. Otherwise, this larger principle that I talk about, Mr. Speaker, would be that in this Parliament, we're going to move motions, we're going to make bills, and we could very well have nothing happening. So what then happens to the people's representatives in a majority situation like this? It means nothing. Is that what we want this National Assembly to see as it being just a facade? So we don't have the power, if we want to, as a majority here, to state that, look, Mr. Minister, certain things have happened under your watch, and of course a no confidence motion. And it is not as if it is breaching the Constitution, Mr. Speaker, by virtue of the argument is proposed, that the President appointed him, only the President can disappoint him. No. We in this country also have solid authority that we can expel, withdraw any member once indeed a motion is to that effect. How laughable. And my dear, they quote a lot of the cases out of it. And it is the case of, yes, it is the case of Jagan and Gadraj. We run it all over the Caribbean, and we have the authority here in Guyana, decided by one of the most brilliant judges we ever had, Chief Justice Lacour. And what he said, at that point in time, what caused the issue in this National Assembly was that the two Jagans did certain things that constituted what the members of that parliament did not like. And the members of that parliament then moved a motion for the withdrawal of those members, clearly out of the place.
What is the year of that case?
And this case is 1963. And we, at that stage, had what is called a colonial legislature. Today we have more, we have a Republican legislature, and we have Section 9 of what is called the Constitution Act, saying that standing orders are applicable. In that case, Mr. Speaker, it is not chalk and cheese. And that is why you're steered away. Clearly you're steered away from the authority, and you want to go quoting Savaruch, Dominica, or St. Lucian case. You didn't want to quote your own case. And this is what it says. On May, what first past the post, the representatives are duly elected here, Madam Gale. So not because it was first past the post from PR.
Honorable members from Mr. Shearer or Madam Shearer?
Yes. And this is what the learned Chief Justice then ruled. The Legislative Assembly, having the power under its standing orders, can regulate its internal procedure relating to conduct, and is the sole judge of the occasion and the mode of exercise of its privileges and power in that regard. Without statutory, and this is number 3, held, without statutory authority, the Legislative Assembly has no power to punish a member for misconduct by way of committal, but has the power without statutory authority to order his removal, expel, suspend, and all that.
If he does something in the house.
And I am saying that even if he did something outside of the house, and he is doing something in the house, we ordered a no confidence motion and he's violating it. That is what we're talking about. You seem not to understand that the convention is being violated. And you just absolutely don't understand that. Yes, that is what they're doing. They're pretending. What was complained of by the Speaker, if held to be well founded, can necessitate his powers to do just as he did. The legislative, that is to withdraw him out from Parliament. He did a very unkind act to the Speaker. And we are saying that what Mr. Rohee is doing National Assembly. And that is what you must understand. You seem not to want to understand that.
Tell us what he did.
All the things that we talked about when we debated that there's an one text motion. And you want, you're not going to go back there.
Take the charge. What he did.
And this is it.
Answer.
Number 4, ruling of the Court of Guyana. The Legislative Assembly has the power to inquire into the question of privilege brought to its attention by the Speaker and to exercise its powers in connection therewith.
In this house.
The Assembly has power to suspend for a limited purpose in this case,
Which is what it should do to you and the international.
my dear, and it has that power to exercise in relation to those. Mr. Speaker, it comes out of the inherent jurisdiction of this National Assembly to have powers so that it can conduct its business.
Yeah.
You don't have to run to some other piece of law without anything else. This National Assembly has that power. And when he was quoting so many cases, Chief Justice, and whenever you have a lawyer by the name of Geoff Haynes, Queen's Counsel, arguing, you're going to get lots of cases being quoted. Mr. Geoff Haynes was arguing this. And indeed, very extensively, all the privileges and immunities and all of that were dealt with in this case. And what was stated? They went through a set of cases and said, that's right, that indeed in these houses, in this House of Parliament, powers should be over members. Otherwise, the House would sink into utter contempt and inefficiency without it. And that is what we are talking about. Without these inherent powers, not the powers you gotta get from some statute or the Constitution, without these inherent powers, it can be very contemptuous, it can be a very inefficient house, and that is what we are talking about. So when the learned Attorney General indicated, oh, there is no law, there is no law. My goodness, the Legislative Assembly, being the legislature, has the power inherent in it. And how do they conduct that? They do it generally by a majority vote of the issue. That is what they do. So you don't have to talk about necessarily, oh, what was the rationale for that? And even the Constitution, Mr. Speaker, even the Constitution says this, that without any reason or anything of the sort, if we bring a no confidence motion against all the ministers over there, 90 days. The Constitution provides that. And so, indeed, if the Constitution provides, if the Constitution makes provision, if the Constitution makes provision for the whole, I cannot see why we cannot have.
That would be to really prove disrespect to the chair again. Could we have Mr. Ramadan complete his presentation, please?
And so, the platform on which the conduct and management of our affairs, no confidence motions, and thereafter, whatever we would like to see as being effectively ensuring that no confidence motion we can bring in this House.
Bring it!
The Constitution makes provision on a certain article that any motion can be brought here, any motion, and it is stated, I think it is Article 171, let me just say, 171,